Today on the program, we take a look at the Supreme Law of the Federal Republic of Nigeria enacted May 29, 1999, since amended January 2011. We discuss the effectiveness of the Constitution having restored democratic rule to Nigeria. We have the views of a constitutional lawyer, Professor Ben Nwabueze, the first academic lawyer to be made Senior Advocate of Nigeria, SAN, strictly on the basis of his published work. Also, highlights of the 30 new senior advocates, including the Attorney General of Lagos, sworn in at the opening of the 2018-2019 legal year. Plus, our question of the week. We go on the streets and ask how the third arm of government has performed since 1960. Hello and welcome to this episode of Law Weekly. I'm Millicent Walker. According to my guest today, the non-justiciability of Chapter 2 of the 1999 Constitution was the making of the then Constituent Assembly, for reasons you'll soon find out, but proposes a solution that could make the proviso that is contained in Section 6, subsection 6C, subject to trial in a court of law. Nigeria's present-day constitution was implemented in 1999, and then, of course, today we have it as amended. But similar to that of the United States Constitution, would you say that it has lived up to its expectations?
I must start with an introduction. I was a member of the Constitution Drafting Committee that drafted the 1979 Constitution, on which the 1999 Constitution is based. I was not only a member, but a leading member, the chairman of one of the subcommittees of the CDC, the Constitution Drafting Committee. Our principal preoccupation at the time was unity, one Nigeria. We were looking for a constitution that will give us that unity, that one Nigeria that we all longed for and aspired to. So that affected the structure of the Constitution. We transferred, just to give an instance, we transferred 50% of the matters on the concurrent list. You know, we have the exclusive and concurrent list. We transferred 50%, exactly 50% of the matters from the concurrent list to the exclusive list. And we didn't stop at that. We look at the residual matters that are residual, and residual matters are exclusive to the states, just as the exclusive list is exclusive to the federal government. We went there and we moved nearly 50% of the matters to the exclusive list. That's the root of the problem that we have today. We were looking for unity, we created this unity. The fight, the battle to control the center, where so much power has been moved, where so much resources, revenue, had been moved. The intensity of the struggle to control the center is what we have today. That is the problem that we have today. Instead of unity, we created this unity.
So how differently could it have been done, or would you have done it? And do you think that it would still help us? I mean, we cannot foresee the future, so you couldn't possibly have known that this would be the results.
Yes, the operators. It's the operators who made the difference. The operators of the Constitution, yes. They created the problem, yes. And the clamor today for restructuring. This is all what restructuring is about. How to reduce the powers at the center. That is the question about restructuring, of which the country is clamoring, agitations here and there. And that root problem, it doesn't stop with the powers transferred to the center. It affected so many things. You mentioned the preamble. I will come to the preamble. When you look at the preamble is dictated by this desire, the quest for unity. We, the people of the Federal Republic of Nigeria, if we want to analyze it, we, the people of the Federal Republic of Nigeria, is there such an entity known as the people of the Federal Republic of Nigeria? It's imaginary. There's nothing like a we, the people of the Federal Republic of Nigeria. You have we, the peoples. There are over 350 peoples of the Federal Republic of Nigeria. The ethnic nationalities, they're all peoples. We imitated the United States, mimic. Now, and it goes on to say, to live in unity, yes, and harmony as one indivisible and indissoluble sovereign nation under God. Can you understand?
Yes.
Yes.
Aspirations, desires,
yes.
is what we wanted.
Yes. But it's not true. Don't project your aspirations too much into the future, as if they are reality. They're not. You create a problem by saying it's an indivisible. The theory of the indivisible sovereignty has been exploded since 1787, the creation of federalism by the American Constitution. It's already divided, sovereignty. We're 36 states, and the sovereignty of the country is divided between the federal government and the 36 states. So why do you contradict yourself by saying that the sovereignty is indivisible, projecting aspirations into reality? It's not indivisible. It is already divided.
So what would you rather the preamble be?
We need a new preamble. We need a new preamble. Remove all this archaic, quaint, they're all quaint phraseology. We have to remove all this. I was asked, oh, why did you allow this? The preamble, this preamble, was drafted by the chairman of the Constituent Assembly, Justice Udoma. And he handed the draft over to me, the preamble. I was the man piloting the draft constitution through the Constituent Assembly. As chairman of a subcommittee, I was a member of the Constituent Assembly by the provisions of the decree that created it. So Udoma handed this over to me, and I said, well, this man, I respected him. We have to accept it and put it like that. That's how it got into the Constitution, this thing. Sounds nice, but it doesn't reflect the reality. We're not indissoluble. Today you have cries for self-determination, for secession. The Republic of Biafra has come and gone, but there's still people, group, agitating for it. This is part of what the quest for unity has led us into. This preamble with this quaint, highfalutin aspiration. Aspiration is good. We must have aspiration. If I were to draft a preamble, I will use the specimen of the South African, the preamble to the Constitution of South Africa of 1996. Yes, very nicely reflecting the reality, the history, the aspiration of the people, and so on.
Separation of powers is provided in sections 4, 5, and 6, giving some powers to the arms of government. Do you think that they have lived up to the provisions in the Constitution?
Yes, that's good. You must have a separation of powers to operate democratic governance. Separation of powers is a necessity. So it's there. You couldn't really have the rule of law without separation of powers. Rule of law, who makes the law? If the executive is allowed to make the law, you can't talk of separation of powers. I mean, you can't talk of a rule of law. So separation of powers is a good thing. Are they respecting it, if that is your question? Today, is it being respected? The executive usurping the powers of the National Assembly. That's the part of the problem. Too much powers. I said the major problem is that in 1976, the CDC, the Constitution Drafting Committee, we moved too much powers from the states to the center. That's the problem.
Chapter 2. How did we get it wrong, making sure that it is non-justiciable?
I drafted the whole of Chapter 2 in my house. The other members of my committee called them to a meeting. Only one person attended. I submitted my report to the plenary committee, chaired by Chief Rodney Williams. And it was adopted and put in the Constitution. My committee recommended that the provisions that you have there, all those rights, economic, social rights, should be justiciable, should be amenable to enforcement by the court. That's what the justiciable means. There was a heated debate in the plenary, in the Constituent Assembly. I looked at the Ministry of Information produced a report called Proceedings of the Constituent Assembly. I looked at it again recently, and the Assembly rejected my recommendation that it should be justiciable on the ground that it will produce conflict between government, the executive, and the judiciary. 2 grounds. And the other one is that judges are not well suited, well equipped to determine such issues, social, economic rights, and so on. And the result was Section 6, subsection 6, C, provided that Chapter 2 should not be justiciable. That's how it happened. It's not the fault of my committee. It's the fault of the Constituent Assembly. It's not the fault of the military government either, because they altered the decisions of the Constituent Assembly in many, many respects, which I have detailed somewhere. I had recommended privately that the section 6, subsection 6, the non-justiciability clause, should be amended to provide that at least every year there should be some kind of plebiscite for the people to decide whether the government is conforming or not conforming